We have finally gotten a decision in CRPA versus LA Sheriff's Department. This was our challenge to the Sheriff Department's open defiance of the Bruin decision pertaining to the issuance of CCWs in the state. Let's talk about it. Hey everybody, welcome back to the channel today. That is right, on the heels of a video that we just did talking about how the court systems were starting to swing again, we get a ruling in CRPA versus LA County Sheriff's Department. This was our lawsuit challenging a lot of the regulations on CCWs, how they were not complying with the Bruin decision set back in 2022. To walk us through it today, he is an attorney at Michelle & Associates. It is Kostas Moros. Thank you, Kostas, for being with us today.
Thanks for having me on again, Kevin. It's great to be on 2 weeks in a row now. That's cool.
Right. But before we get into that today, guys, please be sure to like, share, and subscribe to these videos. It really helps with the algorithms to get this information out there. We want people to be as informed as possible with the Second Amendment as a priority as they're going to the ballot box in November. So, Kostas, let's jump right into this. And well, actually, you know what? Before we jump into this, after reading this, there were a couple of definitional things that I wanted to hopefully clear up with you before we actually get into the challenges. This was a bit of a mixed bag as, it seems like there's going to be preliminary injunctions granted for a couple of the challenges while a couple not. But Jacob, if you can pull this up, I wanted to start with this. It says here, the court thus applies the above Second Amendment framework as set forth in Bruin and Rahimi to each CCW licensing practice challenged by plaintiffs, keeping in mind the Ninth Circuit's doubly demanding standard for granting mandatory preliminary injunctions, which requires plaintiffs to establish that the law and facts clearly favor their position, not simply that they are likely to succeed. Now, we deal with a lot of preliminary injunctions as we continue to challenge laws and hopefully get them to be unenforceable while we litigate. This is a phrase that does seem to come up a lot. You know, you challenge these and you're given the preliminary injunction based on whether or not the merits of the lawsuit are likely to succeed. That's not what this is saying, though. This is saying seemingly that standard is a little bit higher. What's the difference between a preliminary injunction being granted and a mandatory preliminary injunction?
So a mandatory preliminary injunction, the basic difference is that it requires the defendant or whoever the other party is to actively do something, as opposed to a preliminary injunction, which is just stop doing something. So, for example, when Judge Benitez enjoins the state from enforcing a magazine law or an assault weapons ban, all they have to do is stop doing something. They have to stop enforcing a law. Whereas here we're asking for a little bit more than that, and we're asking, in a couple of the claims, we're asking, for example, for the state to process applications from non-residents, which it wasn't doing before. So that's more of an affirmative action they would have to take. It's a mandatory injunction. That said, I think when you show the constitutional claims at issue here, it shouldn't be a significant difference. So I kind of would take issue with the judge's framing in that sense, because this is a Second Amendment issue, that there's a notable difference between the standards. I think if you show you're likely to succeed, you should also meet the mandatory injunction standard.
Right, but that is, I guess, nevertheless, the standard that this judge had in mind as she was writing this decision. And I guess with that, we can sort of jump into the first challenge. While I'll also ask you a definitional question on this one as well. You're talking about the CCW wait times. There were two specific challenges on the CCW wait times. I guess you had one for the individual plaintiffs who were cataloged here as waiting over 18 months past what the law says is the 120 days that the state should have to issue the CCW. And then you have the general challenge of, this should apply to Californians as a whole. Now, the judge spoke a lot in this ruling about facial challenges versus as applied challenges. Can you go ahead and kind of give us the definition of a facial challenge versus an as applied challenge, and how exactly does it apply to this, as we got an injunction specifically for the two people challenging here, but not Californians as a whole?
Sure. So a facial challenge is when you contend that the law is unconstitutional in all its applications. So no matter how it's enforced, it's always unconstitutional. So, for example, a law that bans Christianity. There's no way that law is ever constitutional in any application, right? Whereas a counterexample would be for an as applied challenge, you're contending that the law is unconstitutional as applied to you and your conduct. So, for example, let's say there's a law that says you can't have guns in government buildings, but you live in public housing, and this has been the subject of many lawsuits. Well, even if it might be constitutional in some ways for the government to ban guns in its buildings, it can't ban guns in public housing where people live and they have a right to self-defense. So the court in that situation probably wouldn't strike down the whole law, but they would say when it's applied to people who live in public housing, it's unconstitutional as applied to them. So that's the basic difference.
So applying that though to this decision, I mean, you have the law that says the state needs to get you your CCW within 120 days. She's saying that this applies to these people as a long wait period because it's delayed an extra 18 months. What's the difference between waiting an extra 18 months or waiting an extra day? We have plenty of Californians who are long past that 120-day window, but they can't be included in this. What is the judge's reasoning? What's your thoughts on that?
I think the judge was decided she was only going to rule on the issue before her, which was specifically whether these people who have been waiting, well, one of them was over 18 months, the other one was at the time of our hearing about 15 months, but I don't know when she's setting down the marker. Regardless, she clearly decided she was not going to rule on the broader question, and she got there by basically denying CRPA's associational standing, and I think a little bit unfairly, to be honest, because she excerpted, for example, one of the arguments I made, which was when she asked if she should limit relief to the associations. And I actually argued no, even though it would benefit CRPA, I wanted everyone to get relief. That's our position. We fight for everyone's rights, whether they're a member of CRPA or not. I said this should apply to everyone because you wouldn't want a situation where you're applying for a permit and the LA sheriffs ask you, are you a member of CRPA or the other organizations like SAF and GOA that are plaintiffs here? And if you're not, you're going to go in the slow pile. But if you are, you're going to go in the fast pile. So I didn't mean when I said that if the judge felt she could only give relief up to the associations that she shouldn't, but she seemed to take it like I didn't want associational relief, which is not the case. We were just arguing for the maximum potential relief. Of course, we would settle for the lesser relief if that's all she was willing to give. But this is an issue that we can definitely clear up going forward. So I'm not too discouraged by this. It's a little frustrating, but I think we're going to get there.
What is the benefit here? I mean, you have two people who are going to get injunctive relief who are challenging this as a plaintiff on the lawsuit. We didn't get the injunction for everybody else. What's the silver lining here? Is this positive because it maybe sets a precedent? What positive can we take out of this injunctive relief?
Sure, sure. So there are positives. And actually, it's only one person that's going to get relief because the other gentleman got his permit a month ago after waiting almost 2 years. So really, this is only going to help one person immediately. But what this does is that at minimum, we now have an upper bound. Clearly, whatever long wait times is, 18 months is too long. So we know it's shorter than that. And also, we know what the judge wants to see going forward when it comes to getting the remainder of the relief to show CRPA's associational standing and to perhaps get some plaintiffs who have been waiting a while, but maybe not 18 months, maybe somebody in that 6 to 8 month range to really make this point about how long wait times can be. So there are silver linings. I think we have a clear roadmap now to success. And also, it's possible, I don't know, I haven't talked to the opposing counsel yet, but it's possible LASD may see this, that, yeah, they got a bit of a reprieve, but they might see the writing on the wall going forward. And maybe they'll decide to fix this themselves so we don't have to wait for a final judgment. I know that's wishful thinking, but if we can avoid doing it the long, painful way, we would much rather, settle this somehow, reach a stipulated judgment. But I'm getting ahead of myself because I haven't spoken to them yet. I'm just hopeful that they'll see the way this is going to go.
I guess, yeah, a pertinent point here is that this was a challenge for, or this was a request for a preliminary injunction. So this isn't a judgment on the lawsuit itself. This was just on whether or not to institute a preliminary injunction. So, we got part of that, but we didn't get the other part. But as you're saying, it kind of provides a clear roadmap going forward with litigating this case. Let's move on to another challenge that was on the psychological testing. This has to do with a challenge on the city of Laverne's police department requiring psychological testing and passing that test in order to be able to apply for your CCW. Jacob, if you could pull this one up on the screen, I want to read this one as well. It says, the court observes that in making their arguments, plaintiffs fail to contend on the Bruin framework and have not addressed their burden of establishing the Second Amendment covers the conduct at issue, leaving the court with no parameters for which to consider their challenge. Further, the court does not have a sufficient factual record at this stage of the litigation regarding the actual function of the MMPI to determine whether plaintiffs are likely to succeed on the merits of their claim that the Laverne Police Department use the MMPI involves open-ended discretion. Plaintiffs therefore have not carried their initial burden under Bruin to raise a challenge to the Laverne Police Department's use of psychological testing before issuing a CCW license. The motion is therefore denied as to the challenge. So obviously, it says pretty clearly there, denied preliminary injunction on the psychological testing. I'm pretty curious and a little bit frustrated reading this, and you're going to have to forgive me because I'm the layman over here. You're the lawyer. But it seems to me that there's a couple things being thrown out here. You're literally talking about a barrier for carrying a firearm or not, which is pretty apparent in Bruin is covered by the Second Amendment. How is the Second Amendment not implicated here? And what the heck happened to the status quo? If there's not a sufficient factual record to determine the likelihood of success on these arguments, am I crazy to think that there's not sufficient factual record to proving that the law is constitutional? Because by not giving the preliminary injunction, she's kind of indicating that.
Yeah. So what was frustrating a couple of times in this ruling is how she treats this plain text step. When it came to the high fees, the long wait times, she agreed with us that, whatever the plain text might be, clearly, or she defined it as, sorry, I should clarify, she defined it as carrying a firearm for self-defense without an unreasonable wait time or something like that. I might be screwing up the exact quote, but it was something to that effect. But she didn't carry that logic over to any other category. So, for example, with the psych exam, she could have said carrying a firearm for self-defense without a psychological exam. And then she could have done her analysis and see if we were right about that. I didn't think this, maybe we should have been more explicit in the preliminary injunction, but I never would have guessed that that would have been the trip up, because basically what we said the plain text was carrying a firearm in self-defense, and all these other things, wait times, fees, psychological exam, those are the restrictions that are being tested. They aren't part of the plain text. The plain text is just carrying a firearm for self-defense. So I think that there was some confusion there, and I disagree with how she applied it. That said, we know what she wants. As I said earlier, we know what she wants to see going forward. So going forward, we will phrase it in her terms. We'll make it very explicit in future motions and briefing, and hopefully we'll win next time. Because as she said, Laverne does not show any history or anything supporting their psych exam. We only didn't win because she felt we didn't show the plain text. And I don't think Laverne's going to find any history to support this, nor will the state. So I think we, again, have a good roadmap going forward.
All right, so a little bit of silver lining there as well. Let's move on to the next challenge, which was on the CCW fees. And the judge didn't go into a whole lot of detail on this challenge, other than the fact that the state, I guess, cited that the $1,200 fees doesn't fit the dictionary definition of exorbitant. I'm sort of curious, as this was another a challenge that was not granted preliminary injunction. How exactly do you get over that sort of argument where, admittedly, Bruin has left us with a relative term in exorbitant when referring to high fees?
Sure. So as I indicated, she kind of got us there on the plain text again, which we'll resolve. But on your question, the way you show what high fees are or exorbitant fees is by comparing the fees charged here with the fees charged elsewhere. And you can do that two ways. You can compare to other places in California, which California is generally more expensive on CCWs, but Laverne is higher than even most places in California. LASD, you'll pay around, I think, $500 to get a permit. Laverne is almost twice that. And sometimes more, depending on the exact cost of the training course and things like that. So that's one way to show it. And I think the even more correct way to show it is compared to all the other states that do this. A couple others are expensive, I think, like New York and maybe Hawaii, but the overwhelming majority of states, getting a CCW permit costs less than $100. And we cited these in the motion and in the complaint. So it's not fair almost to have California residents be subject to these crazy fees, especially in places like the city of Laverne, whereas relative to most other places in America, they're paying maybe 10 times as much sometimes. And in some places, I know, for example, I've seen the city of San Jose, for example, charges upwards of $1,400. So that's it's even worse in some places. So I think how you show it's exorbitant is relative to other states and to a lesser extent other places in California.
Well, hopefully that can be shown more and more prudently going forward, as well as there will be more opportunities to argue that one. And then finally, we can kind of end this on a high note. We can kind of group, if we can kind of group two of these challenges into the term of reciprocity. You had a challenge, first of all, on non-residents being able to apply for and get a CCW within the state of California. You also have a challenge on what we typically refer to as reciprocity, where the challenge of California accepting CCW licenses from other states, allowing people to come in and carry here. I've got one more from the order itself. Jacob, can you pull this one up on the screen? It says, without identifying any similar laws before either the founding or Reconstruction, the state has not carried its burden at this stage to show that the limitation of CCW licenses to California residents is part of a historical tradition of this nation. That there were laws from the founding era demonstrating a purported consensus among the states of regulating the manner of carrying within each state does not, as the state argues, speak to whether the state during the founding era limited the ability to carry firearms to only their residents. The state has pointed the court to no history on that point. The state has thus failed to demonstrate that it is likely that its residency requirement to apply for a CCW license is part of a historical tradition of this nation. So this passage was referring specifically to non-residents of California being able to apply for CCWs, and that was granted to us in this order. The one that wasn't was our traditional sense of reciprocity. I'm kind of curious of your opinion on this. How does a judge make a distinction here when the idea really is on both ends, people out of state being able to carry in the state?
Sure. And again, it's becoming kind of a theme in this video, but what she did was back up on the plain text and say, well, you haven't really shown that California not recognizing the permits of other states implicates the plain text of the Second Amendment. It's frustrating to keep hearing that because she seems to pick and choose where she applies it and where she doesn't. But again, we know what to do going forward, so that's okay. What matters now is people who have at least some route. People will have at least some route to be able to carry in California if they do not live in this state. So that's something for now, and we hope to get the bigger relief going forward.
So I guess wrap this up for me, Kostas. Just if you can put a bow on this, there are many challenges here. Line them up for me. What did we win on? And you mentioned that there's a theme here. What is that path going forward?
So going forward, we will tailor the case to how Judge Garnett wants to see it. We will make the plain text, our claim as to the plain text clear, so there's no disputing that what we're implicating. And then the state will have to, the state or the city of Laverne or Los Angeles Sheriff's Department will have to present their history. And we think they have no sufficient history for our challenges here, and we will prevail. And also more immediately, the judge has ordered that we have 30 days to meet and confer with the state on how this non-resident carry thing's going down. So Judge Garnett probably wisely decided, you know what, the plaintiffs are right, but I'm not figuring out how this is going to work. So she ordered us within 30 days to meet and confer, present her with an order on how we're going to implement this, how people are going to apply. So we have to talk with the state's attorneys and see what they're willing to do. We also don't know if they're going to want to appeal this. I think it's going to be a long shot appeal if they do, considering you have a judge that was skeptical of us still giving us the win. You know, this is a Biden appointed judge. She was not a natural, you know, ally to us, at least as far as, you know, as much as you can predict from the president who appointed them. So given that, we don't think a Ninth Circuit panel is going to be any more favorable to the state on this particular argument. That said, California likes to appeal every loss, so we'll see if they do the same here. That's the immediate future of this case.
Well, certainly something to follow along with. We will continue to do so. Kostas, I want to thank you for your time and giving us this perspective on this.
Thanks so much. Great to be on again.
Absolutely. And guys, if you like this kind of content, you want to stay up to date with this Second Amendment battle in the courts as well as the legislature. And if you want to directly contribute to that, please, again, like, share, and subscribe to these videos. Smash that like button because it seems to be really driving the algorithm these days. Thanks again, guys, and we'll see you on the next one.